Thanks for joining this episode of the number 86 lecture series, in which Professor Richard Epstein discusses the Roman law of contracts. Topics in episode 2 include complexities in contractual agreements, the importance of formal terminology, involvement of third parties, how certain contracts would have been enforced differently in the Roman system versus the modern law. This lecture is part of a series with Professor Epstein on how this ancient legal system can provide crucial insights about modern problems. Professor Epstein is one of the most prominent legal scholars of our day. He is the inaugural Laurence A. Tisch Professor of Law at NYU School of Law, a senior fellow at the Hoover Institution, and Professor of Law Emeritus and a senior lecturer at the University of Chicago. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
In the last episode, you discussed the basic principles of contracts and gave examples of relatively simple contractual agreements. What happens when contracts become more complex?
One class of contracts that are extremely important are the formal contracts, known in Roman law as contracts for stipulation. And these are contracts which are primarily used to discharge financial obligations. The financial obligations tend, for the most part, to be relatively certain, and they arise in one of two contexts. First, there could be financial obligations to repay a loan. And secondly, there could be financial obligations to pay for services that have been rendered or for goods that have been sold. And so when you start to deal with these contracts, what you discover is that they are unilateral. And what do we mean by unilateral in Roman law is somewhat different from what we mean by unilateral in the common law. The common law has this very odd class of contracts, which is called unilateral, in which one person performs an act first, and then the other person is designed to essentially thereafter to promise and do something. Roman law does not do that at all. What unilateral means in this particular case is wholly without regard to any prior act. A contract is unilateral if all the rights fall on one side and all the duties fall on the other side. And the opposition to unilateral is essentially bilateral, which means that the obligations, as in the case of buying goods for cash, run on both sides, the seller having to essentially deliver the goods and the buyer having to pay the cash. Now, the difference between these two things is extremely important because when you're dealing with unilateral contracts, the Roman terms was that these were stricta juris as opposed to bona fide. And what stricta juris meant was that we are going to have a very powerful, well-nigh conclusive presumption that there will be no excuses for the performance of this particular obligation. Since one side essentially has all the duties and the other side has all of the rights, it would be very odd to try to figure out why it is that there'd be some reasons that somebody who is in a position of having only claims should somehow or other be required to relax them. There are reasons why this would take place, chiefly dealing with modifications of pre-existing arrangements, but the basic intuition is very strong. On the other hand, when you're dealing with bona fide obligations, the reason why this becomes much more complicated in bilateral situations is what I do may well be contingent upon what you have done. There are so many permutations that can start to take place in terms of these sequence of performance type issues that bona fide is basically the notion which says when you're trying to stabilize these bilateral arrangements, each person has to take that particular act at any given point in time, which is going to minimize the probability of some form of dislocation in the longer arrangement. And that's why with the illustration of having to pay money for goods, we have bona fide obligations you must tender before you can collect, whether you're dealing with the buyer or the seller side. It gets more complicated as the underlying transactions becomes more complicated. Now, since these transactions for stipulation are unilateral, and they typically tend to be for very large sums of fixed money, it becomes extremely important to understand whether or not the obligation itself has been made. And so what happens is in the Roman law, there are basically a series of words that have to be used in order to convey the particular obligation, and a very strict requirement that the words that are used on the asking side have to be used on the answering side. And the need for the correspondence and arguably the need for the specific terms is essentially designed to allow you to determine when the negotiations have stopped and when it is that the obligations have become fixed. So when Gaius starts to talk about this particular issue in the digest, in the institutes, this is the way he goes. He says, do you promise to pay? Yes, I promise to pay. Do you promise to give? Yes, I promise to give. Do you promise to guarantee? Yes, I promise to guarantee, and so forth. And that particular formality essentially has several functions, all of which remain true to this day. One is it allows you to make sure that the seriousness of the understanding is shared by both parties, because formalities like this just don't happen in random conversation. And it's very important before people be bound that they have a clear sense of the obligations that they've incurred or the rights that they have received. And secondly, in the ex post world, what it means is if you've had these particular hard words, the questions of proof are going to be somewhat simplified because of the way in which the particular transactions have taken place.
Can you talk more about the importance of these formalities? What particular terms were used and by whom?
Well, the first complication that you get is who is entitled to use what word when. And this may well seem to be kind of an odd situation, but at the time that Gaius wrote, there was a sharp differentiation between Roman citizens on the one hand and people who were under Roman rule who lived in the provinces on the other. And the term spondio, which means to promise, was thought to be a term with sort of some kind of sacred overtones and so forth. And hence it was only allowed to Roman citizens. So you need to have promises made by non-citizens in order for this commercial system to work. So you had to use another word, in this case promitto, which is an obvious variation on the word to promise, so as to pick up the aliens. And so what you do in effect is you now have two tracks of words that are going based upon this citizenship, and it will apply not only in the case of simple contracts that we start to have, but it will also apply in the case of more complicated arrangements, particularly those which are assumed with respect to guarantees. And then there's an additional set of complications that I'll talk about, known as the ad stipulation, which is essentially the so-called co-creditor, the ad meaning to the basic obligation, which was distinctive in Roman times and eventually faded away for reasons that we can talk about. So having said all of this session is, then what is the particular arrangements that we start to worry about and some of the problems that come up with these formal promises? So one of the questions that you always have to worry about in Roman law is the question about whether or not an obligation survives the death of either the promisor or the promisee. And the Roman maxim was that a personal action tends to die with the person. And this then needs to create obligations that exist in other people who can step forward after the personal obligation is over. In modern law, we don't have that view. What happens is the obligation goes to the estate of the promisor, and it has to be paid out before distributions can be made to the beneficiaries on the one side. And on the other side, the right to get the promise descends to the estate, and so that they could collect. So if you don't have this arrangement, then you have to figure out other stuff.
You just mentioned something that often complicates contractual arrangements: the introduction of third parties after a contract has been made. Can you discuss more about how the Romans handled that situation?
And as I mentioned earlier on, one of these strange sorts of relationships that the Roman law had was called the ad stipulation. And this was a case in which it turns out that you had somebody else who was on the debt. Some people translate the word ad stipulation as joint creditor. That, in my view, is incorrect because the Latin word there is ad, which means two. So it's not as though this person is of equal dignity with the primary or obligor. It turns out that what we're doing is we're giving an additional degree of assurance. So if it turns out that you have this post-mortem problem, somebody else can sue. Now, once you start to do this, you see the following ambiguities start to arise, which is life is much more difficult when you have three parties to a transaction than when you only have two parties to the transaction. Because if you have three parties to the transaction, you first have to figure out what the relationship is between A and B, and then the relationship between A and C, and then the relationship between B and C. And so you get three times the trouble by adding only one party into the situation. And so how does this particular situation work? And well, what happens is you now create this case, typically in order to deal with the situation of death, But in some cases, if somebody was in fact the recipient, the stipulator, and had to travel far away for law, what the co-creditor did was essentially to act as a guarantor of this particular arrangement on the creditor's side, so that you could pick up the arrangement and start to sue. But you're suing as a principal, not as an agent. That's what this arrangement is. So what are the difficulties that you have to have? Difficulty number one that you have to have is there has to be a situation in which it turns out that if it turns out that the co-creditor collects the money from the original debtor, how are you going to make sure that that money gets back to the original and primary party on the situation, the one for whom the benefit is given? And if you go back into early times, we have this following very strange situation, which is the lex aquilia, which is a statute primarily dealing with unlawful physical harm and the destruction of property, between sections number 1, dealing with the death of certain kinds of animals, and section number 3, dealing with the burning, breaking, and so forth of various kinds of things that are not covered by section 1. You have a provision which gives the person who is the primary obligation an action against the co-creditor for the fraudulent release of a stipulation. Meaning, in effect, he goes to the other fellow and he says, you don't have to pay me, I'm giving you a release. At that particular point, the whole thing has been disrupted, and it turns out that if you wish to make a release as a co-creditor of the primary debtor, then you become the primary debtor yourself. There's an interesting question as to whether or not, if this is fraudulent, whether or not the original creditor, the original stipulator, can go after this person. It's, again, these kind of difficult tripartite arrangements. But it also turns out that things are even more complicated than that, because it's not just a simplification of whether or not what you do this thing, it is going to be an outright release. One of the things that you discover with all financial obligations, which is as true in Roman times as there is today, is that sometimes what you want to do is to make a composition of a debt. And what we mean by that is there's a fixed and permanent obligation to pay 100. The fellow doesn't have the 100. And so he comes to you and he says, if you give me a complete and full release, I'll pay you $80 today. And if you don't do that, I can't pay it today. You could take your chances of finding me tomorrow. And it may be that I'll only have $20, or some other creditor will have come into place and swooped away the asset that I've had. And oftentimes it is the case that what happens is you make one of these compositions in perfectly rational sense on the theory that $80 in hand or 80 sesterces in hand is worth more than $100 a sesterce in the books. And so these are good faith composition. How do we know this? If you get rid of the ad stipulator and simply look at this as a transaction between the two original parties, the most common thing in the world is to accept a partial payment on a debt as a complete release of what's going on. And generally speaking, under Roman law, the partial acceptance would be binding. We'll talk about that later. Under the common law, it was genuinely quite difficult to figure out whether or not this thing as a release was binding. This is an area in which the clarity of the Roman law was generally more serious than that of the Anglo-American. Now, if you're doing all of these things, you then have to worry about the question is what kind of judgment is the co-creditor making in dealing with this sort of situation? And this is the way in which the problem starts to work, is there are some cases where, in fact, it's a sweetheart deal. And to give you the ugliest form, what happens is the guy says, look, I'll accept $80, and then he gives $5 on the side back to the guy for the release. And generally speaking, if you're a co-creditor and money comes, it has to go back to the primary obligation, and you could treat this as a bribe for the release. And that's behavior which would be in bad faith. And so as the law becomes more modern, the stipulation is not governed by the contract of, or this particular action under the lex aquilia. It's governed by what they call the actio mandati. This is the agency relationship in which I represent you in a transaction with a third party. And now I'm under a good faith obligation to make sure that any settlement that I make with that third party is honest. So I can bring the actio mandati if it turns out I'm claiming that the release was given in bad faith. And of course, the defense can take place to saying that it's in good faith. This is not an easy line to draw in many cases because often there are dual motives, or there's genuine uncertainty about the status of the debtor, genuine uncertainty about the knowledge of the co-creditor with respect to what's going on in these cases. But it's quite clear that the Romans sort of understand the issues that are at risk in this particular case, and hence they can deal with them. The other question that you start to do, again, is you have to worry about death. And when Gaius reports this kind of arrangement, he says, quote unquote, one of the more peculiar features of the ad stipulation is that the action does not descend to the heir under any circumstances.
Why wouldn't the action descend to the heir? Why is that a logical consequence?
And why does that turn out to be the case? Well, think about it. What happens is you pick Mr. X to be somebody who's going to be your guardian. You didn't pick his children, you didn't pick his son or anybody else. And so these obligations are peculiar obligations of trust. And the general rule is that these cannot be delegated by the person who's subject to the obligation to some other person. Because your ability to rely on somebody whom you don't know, it's going to be more likely he'll act in bad faith, more likely that he'll keep the money and so forth. So what happens is the ad stipulation drops. Now, what do you do in order to respond to the possibility that your ad stipulator may die? And sometimes what you do is you take more than one ad stipulator, sometimes for the same full amount. Sometimes you take half from this and half from that so as to diversify your particular kind of portfolio. And what you're trying to do in every case is to make sure that when the money is collected by the co-creditor, it gets turned over to the principal, an issue that we have to face today. There's also another rule out there, which again makes perfectly good sense, which says that under these circumstances, the ad stipulator cannot be a slave. Now, why is it that you have that particular rule? Because the slave is already bound to the master. And so anything that the slave gets, the master gets first dibs on. So it's going to be extremely difficult if the master can claim everything that is collected under these circumstances, that it turns out that the actual creditor can recover from the slave's master, because he certainly can't recover from the slave. So what the Romans did is they developed this very, very elaborate system. It's described in immense sophistication, and in effect, every single risk that you can imagine, they cover with. So what happens? Well, the institution eventually dies. And why does it die? Because what we start to do is to develop more mature agency kinds of relationships. So what the creditor can do, the stipulator can do, is to take somebody else and says, I would like you to be my agent for the purpose of collecting this particular debt, and then you have to turn it over to me. And you can appoint the agent for collection at any time, not only at the time of the formation of the debt, but at any time when you want to collect. So the arrangement turns out to be more flexible, given the fact that you could wait a little bit longer before you have to commit to this thing. And so the ad stipulation no longer seems to have any use, and so it disappears. And by the time you get to Justinian, there's no trace of it. And this is one of the kind of interesting lessons that you learn about Roman law, which is if you had just looked at Justinian before Gaius came around, and you had tried to guess that there had been this kind of relationship, you'd never be able to figure this out, because you would not have essentially an awareness that the action for agency was always thought to be difficult, because all obligations were thought to be personal. And so in agency relationships where you hire somebody was thought to be a real stretch about the way in which the system worked. And then when you put it into place and you have the mandate, well, you have all the same problems you had before. This agent can forgive a debt which he ought not to do. The agent can take the money and then divert it to some other purpose. So it's not as though the standard risks of delegation don't exist. It's just that they take a place within a simpler framework. And the systematic advantage is that you can pick your agent at the time of collection rather than having to pre-commit this arrangement very early on.
What other parties might be involved in this type of arrangement?
Then there's the other side of this thing, which is perhaps more important, which is the problem with respect to the guarantor under the contract of stipulation. And what you do is you look at the Roman text, and it turns out that there are three kinds of guarantors that you can have in Gaius. One of them is called the sponsor, spondeo. Then there's a fido promittor, and then there's the fido iusor. And so the question is, why do you have three terms with respect to these arrangements? And this illustrates two themes. The first theme we've already alluded to, which is that the term spondeo is thought to be freighted with significant religious significance that it's not going to be available to people who don't meet the requirements of Roman citizens. On the other hand, you're going to have some other way and some other transaction to do that. And just as the word promitto became a substitute for spondio with respect to primary obligation, fido promissor means you are loyal to somebody. This becomes a guarantee. And then there's the fido usor. Well, what's going on is that you've got these two classifications of creditors, and the Romans then do something very smart. They say, look, we now have these two flavors of arrangement. And what happens is we have very strong signaling effect. And what we mean by that is once you use the word sponsor or promissor, fido promissor, what we're doing is limiting ourselves necessarily to certain kinds of arrangements. And so, for example, just to take one of the many variations about this, suppose what happens is that it turns out that there are multiple guarantors. And it turns out the principal debtor defaults on this kind of an arrangement. You then have to worry about the question as to whether or not a particular promissor is liable for the entire debt or is only liable for a pro rata share of the debt in question. And the forward promissor situation tends to say we're going to only do the proration. Then you have to worry about the question of what are you going to do if one of these people dies so that that obligation falls out. Then you have to worry about the question if they're prorated and one person pays, when there are 10 potential guarantors, pays 20% of the debt, can they recover the excess from the other parties? Then you have to worry about the further question as to whether or not if you actually pay these debts to the third party, can you recover the debts either individually or collectively from the underlying first promissor? And essentially what the promissor-sponsor arrangement was is that the creditors who took these things on essentially were less likely to be hit financially than the fido usor, which was the other guy, in which if you had multiple people under these circumstances, each of them was bound for the whole with respect to the other parties so that you didn't get the forgiveness by virtue of the sharing. So if you look at these kinds of arrangements and you ask yourself, what's going on here? What you discover is in financial arrangements, what you want to do is to have very clear categorizations so that people will know what the nature of the obligations are. And one of the reasons why you want to do it is to make sure that the relationships between the guarantor and the original promissor are there. But there's also the other problem that happens is, suppose you start with one of these guarantors and then you want to add another. If, in fact, when you use a word like promissor, it has a clear meaning, anybody else who's coming on will know what the obligations are vis-a-vis that party because these standard terms are completely inflexible. Whereas on the other hand, if you use the word fido usor, you now know that it's a different set of expectations, but it's also clear. And so what formality does is it gives notice to the rest of the world about the way the transactions work, so that by standardizing the relationships, people who are coming in later on can get a better assessment of what the risks are going to be like.
So is formality the most important element of contracts?
Standardization turns out to be the absolute key on this thing, because when we tend to think about contracts often, we think about them as unique engagements between two individuals where a lot of product differentiation and unique determinations are there. But when you're dealing with arrangements where the unilateral promises to pay money, these variations are relatively unimportant in these things, and what really matters is that you get clarity in terms of the way in which the way works. Now, does this have any application to modern worlds? And the answer is, let me give two, which I think show how it works. One of these things that we have typically in Anglo-American law, the difference between a bill and a note, a check and a note. And what's the key difference between the two of them is if you're talking about a check, it means that if you write a check out to somebody else, this check is freely negotiable, so that if it's transferred in the ordinary course of business to a holder in due course, they can sue the original obligor on the check for the full amount of the situation. And that's true even if there's a beef that the original promissor has against the party to whom they'd given the goods. So essentially what you're saying when you give this thing, it's like money. It goes free and clear to somebody else. Whereas if you used a note and you sign that to somebody else, the rule with respect to a note is that the assignee, takes subject to all defenses that could be raised against it. Which of these two arrangements is better? Nobody can say in the abstract, which is why that both of them turn out to persist for hundreds, indeed probably thousands of years. But the important thing is to have an absolutely clear line between them so that when you get this piece of paper, you know whether you're in the world in which you take free and clear of defenses or in the world in which the defenses exist. And that will determine the way in which the pricing of these things will start to take place. You will pay more money to get a free and clear obligation than you will pay to get something else. And so the same kind of formal distinction takes place here. So if you look at your standard check, there are basically only 4 boxes you could fill in: the date, the payee, the amount of money that's paid in numerals and then in thing, and then a signature. The moment you start adding a condition, only payable if goods are delivered, it's no longer a check. And so what happens is the clarity of the form essentially allows the third parties to know. The other point about standardization has to do with modern transactions and securitization. And typically what happens is that when people originate loans in a given territory, there's a kind of lack of diversification with respect to the geographical stuff. These particular loans, they're all coming from the same farm area. If it turns out there's a flood on one, it's likely to affect all the others. And so what happens is if you've got a bunch of loans all drawn from the same neighborhood, there's a risk that if one goes bad, all will go bad. And generally, people like to have diversification. So what you want to do is to put these loans into portfolios with other loans coming from other territories and slice them and dice them in other ways so that the first payment may well go to one guy from a particular loan, the second to another, and so on down the line. What you discover in this case is the only way that you can securitize loan is to standardize all their collateral terms. Otherwise, when you put them into a big bundle, some of these loans may have defenses that are not available to others, and nobody can quite figure out how the portfolio works. And so it's exactly the same principle as the Roman Fido Usor and Promissor. When you want obligations to be built for speed, what you have to do is to slim them down so that everything turns out to be absolutely standardized. And so those are the conditions that are imposed upon modern portfolios. What they've done, in effect, is they've updated the same kind of stuff that you had when you're dealing with the contract of stipulation under other circumstances. So now what we've done is we've talked about these 3 kinds of parties and so forth, but there are other kinds of things that we have to worry about in addition. And one of the things, again, involves the question of third-party beneficiaries. And just to rehash the terms, in a standard kind of contract, there can be 3 people, not 2. Person number 1 is the obligor or the promissor. Person number 2 is the promisee. And person number 3 is the party to whom the promissor agrees to make the particular payment in question. And since you tend to be talking about stipulations here, you're not talking about the performance of diffuse service obligations for the most part. What you're talking about is the payment of particular amounts of money. And what happened is the Roman law and the English law often devoted a situation in which they had the principle of privity of contract. And what that meant was that only the persons who had signed the agreement would be able to obtain any rights with respect to the whole thing. And, you could see what's going on there. What it does is it eliminates that third party. And if you think back to what we said about the ad stipulator, every time you have a tripartite relationship, it becomes a lot more complicated than if you have a two-party relationship. And so simplification is there.
Can you talk more about arrangements that necessarily involve third parties, either as debtors or beneficiaries?
But of course, this promise is not a promise which we have to inflict harm upon the third party. And if A and B enter into an agreement whereby they agree that C will pay each of them $100, if you allow that agreement to go, civilization as we know it comes to an end, because now any two parties can always exact anything from any third party. And so you have an endless array of promises binding strangers to them. You don't need a detailed explanation for the inefficiency of these arrangements. But on the other hand, when you have third-party beneficiaries and somebody writes an agreement and says, I hereby agree to pay it to somebody else, what ought to be the way in which this particular thing should be treated? And so the Romans start to deal with that. Well, one of the cases they give is a situation in which the rule is, if in fact we make the payment to the third party, now everything has been discharged, and so there's no right of action that the promisee has against the promissor, the stipulator has against the promissor, because everything has been discharged. But suppose the thing has not been paid. The question that you then have to start to ask is whether or not the third party can sue on this particular obligation. And the Roman law said that they could not. And this immediately gives rise to a very interesting kind of puzzle, which is why is it that there's a reason of positive law to impose the privity of contract restrictions on people if, in fact, what they say between themselves is, we hereby wish to make a promise. A makes a promise to B that A will pay C $100. A wants C to have the enforceable right of action. Is there any reason to override their particular consent under those circumstances? And people become very hard-pressed to say that there is one of these things, and yet the law remains pretty stubborn on this point, subject to fixes that we talk about later. And so the early view was that these things were essentially unenforceable. What's the logic behind it? The simplest thing is, as we mentioned before in connection with ad stipulation and other kinds of promissory relationships, it often happens that you get yourself a situation and somebody wishes to modify the original kind of obligation in question. So if it were simply a payment to the promisee, you may say, I'm going to cut this down from 100 to 80. You may say, I'm going to postpone payment by a week or by a month and so forth. You may add a condition in. The moment the third party has a vested right, then all of that goes out the window, because now when they try to modify the promise, they're modifying the rights of a third person, and he can veto the transaction. It is generally the case that most people to the original obligation are very reluctant to have that kind of limitations imposed upon them. So if you look at modern contracts under the American law, where third-party beneficiary contracts are enforceable, generally speaking, what you see is two things happening. One is they're very, very careful to give a very narrow definition of which third-party beneficiaries can sue. Because if you're a so-called incidental beneficiary, somebody who's going to benefit, say because the house next door is going to be built and make their life a little bit nicer, those people don't get sued, and you have to be designated to sue. And then when you actually look at written contracts, what you typically discover is that they contain the following kinds of clauses as a general case. Nothing under this particular agreement creates any third-party right whatsoever. The two parties reserve the right to alter the agreement as between themselves. And so in a world in which there's some loose presumption in favor of allowing third-party beneficiary contracts, what you see is something very instructive, contracting out of that kind of an arrangement in order to preserve the initial facility.
Clearly, arrangements with third parties are much more complex to navigate. Did the Romans try to avoid these types of contracts?
So at least it tells you something about the intuitive wisdom of the Roman system, which is you try to create two-party relationships. You're very reluctant under these circumstances to create three-party relationships because of the mechanical difficulties that are otherwise going to take place. And it turns out that makes sense. Does it make sense in all cases? And it's like everything else, the answer turns out to be no. And so what we want to do is to go back to a problem that we've already faced. What do we do with obligations that are only going to be enforced after the death of either or both of the parties? And the modern version of this is essentially the life insurance contract, in which somebody essentially goes to an insurance company and says, what I would like you to do is to pay after my death $10,000 to Miss X. And what happens is Miss X is not a party to that contract. If, in fact, what you say is you have no third-party beneficiary rules under these circumstances, then at the death, the person who has the right turns out to be the heir of the original promisee. If you go back to what we said about the ad stipulation, it's quite clear that the interest of the heir may easily diverge from that of the original promisee, and she or he may decide to keep that money for themselves and not hand it over in due course to the person who is named as the beneficiary under the insurance contract. Now, this third person hasn't paid anything. They're classically a gratuitous party. But if you're an insurance company, you're trying to sell a policy to somebody who says, I want you to make this payment after my death to that person over here. And they says, I can't guarantee you that because these third-party promises are not enforceable. There's a serious risk that this market is going to somehow or other collapse, or you're going to have to devise some very complicated business sorts of arrangements in which the payment, instead of being made to the heirs, is going to have to go to somebody else, but who and whether or not they'll discharge the obligation are open questions. So what you can do is you can take one of two attacks on this, and one of them is to say, well, we have to reverse the general rule, and that's foolish because then you sweep in all the commercial arrangements where people don't want these rights. The other thing to do is to pass a statute, which is what happened in England, in which you announce whenever there's a life insurance contract, after the death of the person on whom the contract is written, the action can be enforced by the person who's designated under the contract. It's very clean. It makes a lot of sense. And so what you discover is, as you get distinct kinds of contracts, generally speaking, the world that you're going to be in is a world in which you try to give tailored solutions to particular problems as they arise, rather than relying on general jurisprudential principles that everybody can be able to do everything that they want. And sure enough, these problems, again, are not time-bound in any obvious sense. And the issues that we're talking about on the post-mortem stuff in England in 1915, when the statute is passed, are identical to the post-mortem stuff that you have underneath the various forms of the Roman law.
What other types of complexities might enter into consideration for contracts?
There is also a very long and learned discussion in Roman law about the following question. Can you make various kinds of stipulations subject to conditions? And if so, what are the conditions that are permissible and which are not? And so, for example, to take a perfectly innocuous condition, what you can say is, if it turns out that X dies, I hereby agree to pay you 1,000 sesterces. And that's, of course, just a contract of insurance written on the life of the person who happens to die. And the reason why you want to make it conditional is that if you've paid a premium in a separate transaction, the last thing you want to do is to say that the money is never owed or is always owed. You're making a bet on the life of this person. And what the condition does is allows you to make the obligation work under these kinds of circumstances. But sometimes the Romans get themselves a bit more speculative. And so one of the things that you would start to say is, can you make a promise on the sense that I will pay you 1,000 sesterces if it turns out a hippopotamus learns how to fly? And you start looking at that promise and what are you talking about under these cases? What's going on here? And at this particular point, there's something vaguely absurd about the way in which the stipulation is going to be put into effect. And so what you have to do is to decide whether or not to ignore the contract or to decide, in effect, that the condition is what's to be struck and the promises are what is to be kept. And the Romans constantly worry about the question of whether this thing is inutilis. And inutilis means unenforceable because of the fact that you've got this strange appearance that would never occur. And somebody will come up and say, well, why are we doing this? Would somebody ever want to make a conditional contract when the condition can never be satisfied? And so that becomes a kind of an academic sort of question. But it becomes fairly important in the following case. What happens if it turns out that you do this in a contract on the one hand, or you do it in a will on the other hand? And it turns out that what Gaius says is the general rule is that we regard the thing as unenforceable because of the impossible condition. And he said the rule turns out to be good with respect to contracts, but not with respect to wills. And he says it's very difficult to find a reason why it is that we accept this particular kind of differentiation. And so the question that we then have to ask is, can we come up with that reason? And I go back to my own teacher, David Daubert. He says, of course you can find the reason. And again, it has to do with the peculiar status of post-mortem transaction. Suppose it turns out that the person is alive and kicking, and immediately you understand that this particular transaction is void. If they really want the promise to go through, they could draft another agreement, get rid of that condition, or put in one that's more sensible, and the life will go on. But if it turns out you're talking about a will, what happens is the will only takes effect at death. So anything you do before death to modify a will is anything that you want to do. But after the will becomes fixed, and old Daubert used to say, look, under those circumstances, if in fact you treat this thing as though it voids the underlying obligation, you cannot expect the heir or the beneficiaries under the will to follow the quorum of somebody else. And so therefore what you do is you void the condition under those circumstances instead of voiding the obligation on the grounds that he purported to do something and it's beyond his power to sort of correct the overall situation. If you go forward in both Roman law and an Anglo-American law, where these obligations now are allowed to descend, what you often discover is very strange things start to happen when it turns out that there's a promise made by a given person who then turns out to die. And now the heir decides not to honor it. And what it is it goes essentially to consideration and all sorts of bargained arrangement.
Would this situation be handled differently in modern law versus Roman law?
Under the Anglo-American law, if there's no consideration for a particular promise, then the thing is not enforceable. And by consideration, we basically mean that if I want to get something to you, I have to sacrifice something to you. I either have to promise to do something for you or have to forbear to do something that I'm otherwise entitled to do. And it's a very narrow restriction. Roman law does not have that as a universal principle, but the common law does. And so what you do is, in the most famous case called Williams and McGowan, you have a situation where somebody is standing on the ground, his employee is up top, and a log starts to fall on his head, and the poor employee rides this thing down, saves the master, who then promises to pay him $10 a month for the rest of for the rest of his life. And then he dies, and his estate refuses to pay the money. You can see what the risk is. So they now go around, they're just outraged about this because they understand what the intention is. And they don't think that this was a bargain because the so-called consideration was past. That is, everything that was supposed to be done lay in the past, not in the future. And so therefore it's not a bargain, but it's a gift conditional upon something happen, which is gift meritorious. Romans would have very little problem in enforcing this promise. And so what the Anglo-American law does is it starts to invent other exceptions to the consideration doctrine in order to let this thing go. And this is a lesson that every lawyer has to understand, is whenever you negotiate a contract with X, it turns out that the assignment risk and the postmortem risk is always there. And going back to what we started with usufruct, is the moment you change the nature of the person who's the obligor, you change the nature of the particular risk in question. And this doctrine applies whether you're dealing with leases and subleases, with usufructs and assignments, with delegations of particular duties. At every case, it's relatively easy to make an assignment of a right to collect a fixed sum of money because that right is fixed no matter who gets it. But if it turns out you're on the other side, the credit risk or the performance risk becomes great. And so you can now start to understand why it is that these various kinds of restrictions that are imposed upon this particular contract of stipulation.
Thank you for listening to this episode of the Number 86 lecture series. The spirit of debate of our founding fathers animates all of the Number 86 content, encouraging discussion and critical reflection relative to how each subject is widely understood and taught in law schools and among law students. Subscribe to the Number 86 lecture series on your favorite podcast platform to have each episode delivered the moment it's released. You can also go to fedsoc.org/number 86 for lectures and videos on federalism, separation of powers, the judiciary, and more. That's fedsoc.org/NO86. Thanks for listening. See you in class.